He had been calling me nonstop. He wrecked my car.
The reality was an eye-opener.
And what did you find when you got there?
My car on top of 9 fence posts and chain link fence wrapped underneath of it.
Now her nightmare continues.
He says he wasn't even there. It doesn't get easier. It's just going to get harder.
This is Judge Judy. Brianna Collins is suing her former friend, Nicholas Brown, for driving her car without permission and wrecking it.
Judge, this is case number 63 on the calendar in the matter of Collins versus Brown. Parties have been sworn in.
Miss Collins, it is your claim that the defendant, who, according to you, you knew only slightly, took your car without permission on August 11th of this year and had a bad accident with it. You want him to be responsible for all of the repairs. The defendant doesn't deny that he drove your car. He said he had your permission to drive it. He returned it. He doesn't know what happened to it after that. So why don't you, in your own words, tell me first how you know him, second, the story about the 11th of August when your car was in a ditch.
Well, I met Nick from... I take care of this older gentleman. He's kind of like an uncle to me that lives on our property right behind us. And that's how I had met them, was through them. He had came over and knocked on my door and asked me if he could have a ride home or just if he could have a ride down the road, is what he had said. And I told him after I put my kids to bed that I would take him. And I fell asleep in the process of putting my kids to bed. And that usually happens, though. So, and then I woke up on the 4 o'clock in the morning saying that he needed my help. And
you woke up. Now that's I know what you memorized, madam. Now I know what you memorized. Now I'm going to stop you. So now you're singing your children to sleep, and you were awakened 4 o'clock in the morning. You see how we're smiling at each other? And you were awakened 4 o'clock in the morning. It doesn't get easier. It's just going to get harder. You were awakened by what? 4 o'clock in the morning.
My phone. He had been calling me nonstop.
So your phone, well, you don't know that because you were sleeping.
Well, you're right.
Right?
Yes.
So you don't know that because, according to you, you were sleeping. But you finally heard your phone.
Yeah.
And answered your phone. And on the other end of the phone was the defendant. Go ahead.
Stating that...
And?
He had...
He said, no, not stating. He said.
He said that...
What did he say to you?
He wrecked my car. And that I needed to come and pick it up.
Was?
Yes, he had said that he was down by the State Patrol office. Sorry.
He said he was by the State Patrol office.
Yes.
I assume you knew where that was.
Yes.
So what did you do?
I woke up my significant...
No. Look at me.
I woke up my significant other and asked him if I could use his car to go and see what was going on.
How did you wake him up?
I hit him. I, nudged him. Hey.
Well, where were your children?
They were asleep in their room.
Well, so at some point, what you said to me was I was singing bedtime stories to my children, and I fell asleep.
Yes.
At some point, you left your children's room and went back to your significant other's room.
Yes.
About what time was that?
I have no idea. I did not look at the phone, and I didn't think anything, I don't usually. I just get up and go to my bed when I am told that, hey, you should get out of the girls' bed.
I told you it was going to get worse. Now, so you woke up your significant other, and what happened? What did you do next?
I showed him...
What did you do? What did you do next?
I told him I needed his car so that I could leave to go and check out my car.
Okay. And did he give you permission to take his car?
Yes.
So you drove alone to area?
Yeah, it wasn't exactly there, but down the road.
And what did you find when you got there?
My car on top of 9 fence posts and chain link fence wrapped underneath of it.
And where was the defendant?
Walking up to me, telling me that he was sorry.
Just a second. So he was walking up to you?
Yes.
Did you both wait for a tow truck?
Yes and no.
Is not an answer.
No and yes. I had went back. He had thought that we could tow my car myself. And it did, because it didn't look like it was as bad as it had seemed, I guess. So he opened my trunk and he tied together my jumper cables and he hooked it to my car. And I was like, this is not going to work. This is not going to work. Just stop. And so I went back home in my boyfriend's car to go and get the truck and bring the truck there so that we could tow the truck home and not have to pay for a tow truck. But it didn't work out like that. By the time I had
Well, how did it work out?
By the time I got back to the accident, the tow truck guy was already there and attempting to get my car off of this fence post.
And
it cost us $350 for them to tow it off of there into my house.
Just a second. Where was the defendant?
Standing right there.
Okay. Did anyone make...
What I did was file... I didn't press any charges or anything on him because that would have done me no good. He can't pay for my car while he's sitting in jail.
I just want to see a police report.
I don't
when there's
have
an
one.
accident like this, there's usually a police report.
I don't have one. I was never given one.
Well, you have to call the police in order to them to write a report. They're not sitting around waiting, say, oh, gee, maybe I should drive by this area and see if there was an accident.
Yes, I was.
So you didn't make.
I didn't.
You didn't call the police.
They were already there.
The police were there.
Yes.
Yes. Oh, interesting. When did the police get there?
Before I arrived. I'm not sure.
So there is a police report somewhere. There has to
yes.
be. If the police were there has to be a police report.
Yes. I wasn't the one that wrecked the car. I didn't really talk to the cops.
That doesn't matter. Well, but you were the owner of the car.
Yes.
So the owner of the car, if the police are taking a report, they take down the name of the driver and the owner.
And that was all.
Now, you knew you were coming to court today. You live in Los Angeles?
No.
Where do you live?
In Washington, Moses Lake, Washington.
In the state of Washington? Yes. Well, this may come as a surprise to you, but in court you're supposed to bring evidence. I've recorded who was driving the car, who was the owner of the car, because the defendant says he wasn't driving the car when it ended up in a ditch. Isn't that what you said to me in your answer, sir?
Yes, it is.
So, do you have a copy of the police report?
No, I don't.
Well, why don't you get it? She's alleging that you took her car, or at least that you were the driver of the car. How many police responded to that? One car or more than one car?
I have no idea.
How many police cars were there?
When I had arrived, there was one. By the time it was all over, there was 3.
So there were 3 police cars, and according to you, he was there.
Yes.
Because you told me a moment ago that he was there when you arrived. And if the police were there when you arrived, he must have been there, which could settle the whole thing, right? All you need is a police report. So I am going to do this for you. I'm dismissing your case.
I have text messages.
Without prejudice to you furnishing me a police report. And if the police report, which it will, indicates that he was the driver of the car, I will enter a judgment for you in the amount you request, which is $3,000. But the police report must say he was driving the car. Do you understand?
Yes, I understand. Sorry. I believe that I have actually, because the photos that I brought were from the police. They had emailed it to me. I believe that I have that, in my email.
You believe that you have a copy of the police report that says the defendant was at the scene when they were there and had been driving the car?
It does state that Nick Brown is the one that wrecked it, yes. I'm pretty sure, yes.
Well, take a look at it. Take a look at the report.
Because he received the ticket and
No.
So
No.
I never saw any of it.
Well, let's see. Just find it for me. I'm more than happy to look at it. Mr. Brown, they wouldn't make up your name, right?
No, they wouldn't.
No, I guess I don't. All it is the case number and everything. The case number and the photos and the invoice because I had to pay for them.
Do you understand what my
Yes.
ruling? All I need is a document. I will allow you to get it, but I'm dismissing your case pending you getting me that document. A document from the police that indicates on the 11th of August of 2020, they responded to a car, your car. The defendant was at the scene, admitted to driving. He says he wasn't even there. He says he doesn't know if police arrived or any. He says he doesn't know. I don't want to see text messages between the two of you. I want to see the police report. Do you understand?
Yes.
That's very easy to get.
Yep.
All you have to do is ask.
Yep.
Thank you. We're done.
This case is concluded. Parties are excused.
My car wasn't there, and he was on the phone saying he wrecked it.
Left the keys in the ignition like they usually are, and took off. And I don't know what happened.
I'm just going to get the police report.
She gets a police report, then fine. But if she can find it.
All parties in the matter of Watson versus Young. Step to the podium, please.
Rosie Watson is suing carpenter Kellon Young for a refund for unfinished work on her staircase.
Miss Watson, it is your claim that you hired the defendant to do some work on the steps in your house.
Yes, ma'am.
You gave him a check for $800. He left and said he would be back to finish the job in a day or two. A couple of days later, according to your complaint, an older gentleman appeared and started working on the project and was there for a relatively short period of time and left.
Yes, ma'am.
You want your money back.
Yes, ma'am.
Mr. Young says that you were a pest and a micromanager. He did $800 worth of work, and then he said, anymore. That's your defense.
Yes.
Is that what you're telling me?
Yes.
All right. Good. Then I'm going to start with you.
Judge Judy continues in a moment.
She actually wanted me to cash the check, and I would use the money to buy the stuff with.
So she paid for the materials herself.
No, she didn't pay for herself. It was out of the money that she gave me.
Well, that was her money. So far, you haven't
yes.
done anything.
Rosie Watson is suing carpenter Kellon Young for a refund for unfinished work on her staircase.
Okay. Tell me what your business is.
I mostly help friends and family with their homes and apartments.
What kind of work were you supposed to do for the plaintiff?
I was supposed to repaint some stairs and then replace some damaged wood.
And when did she give you the check?
She gave it to me like a day before I started the work.
On what date did you give him the check?
On April 27,
Just give me
2020, Your Honor.
So you're telling me that you came back to her house on April 28th.
No, first.
Is that correct?
Yes, but we first went to Home Depot together to purchase the items.
Okay. And did she put that on her credit card?
No.
Or did you put that on your?
The check, and I would use the money to buy the stuff with.
Is that what you did?
Yes.
So she paid for the materials herself.
No.
And how much were the materials?
No, she didn't pay for herself. It was out of the money that she gave me.
Yeah. Well, that was her money. So far, you haven't done anything.
Yeah, yes.
So far, she paid for the materials.
Yes, yes.
How much were the materials?
We spent like $300.
Not we.
Or I spent $300.
She.
She spent, yes.
She spent
Yes.
$300. How much was the receipt from wherever you went to purchase the supplies? He said it was about $300. Do you recall?
Your
or
Honor.
do you have the receipt?
Your Honor.
What?
Absolutely not. He's lying to you. This broke hustler has stolen from so many people, he ought to lock himself up.
If you don't answer my questions.
There was no
don't
receipt,
answer
Your
my
Honor.
questions.
There were no purchases.
Just a second. Okay. So what you're saying is the two of you never went to a Home Depot to buy supplies.
Yes, ma'am. I gave him $800.
Just don't get ahead of me. You gave him a check on April 27th for $800. When was the next time you saw him?
About 3 days later, he and I met at the Home Depot. He purchased one can of paint.
Just a second. 3-day text or telephone communications to meet at Home Depot.
Yes, it was a text message that we...
May I see it?
Yes. Where it says, okay.
Just a second. Okay, so you met at Home Depot, and that was on Wednesday, the 29th. So that was 2 days after you had given him the check.
Yes, ma'am.
And then, sir, pay attention. According to the text, you bought a can of paint. Mr. Young.
No, according to her.
According to the text, you...
I didn't
No,
just buy
that's the text. Well, then you should have kept a receipt. You said, I need a can of paint to paint the railing. Can you bring a chip?
That's for the railing. That ain't for the steps. So she's not showing you the right text,
now,
I guess.
You'll show me your evidence when you show it to me. When was the next time you went to her house?
We went that same day. Someone was already there working already that same day. Someone
was
there.
there?
Someone was there prepping and... The guy who
was
helps.
there?
There's a guy who helps me.
What's his name?
Charles. And Charles was there.
Charles was already there on the 29th.
Yes.
When had Charles gone there?
When I dropped him off, probably like 8:30 or 9.
On the 29th. Miss Watson.
Yes, ma'am.
Is that when this gentleman that you...
Yes, ma'am. And he did about no more than 2 hours worth of work. Absolutely. Mr. Young.
Okay.
Judge Judy continues in a moment.
Someone showed up and did an hour's worth of work and left, so you did see someone. So let's not get fixated. Who you refer to an older gentleman, don't tell me what he did. He showed up.
Real cases, real people. Judge Judy. Rosie Watson is suing carpenter Kellon Young for a refund for unfinished work on her staircase.
Okay, when you got back at 3:30 from getting the paint, you met him there, you bought a can of paint, and then you went home. Did he go home with you?
No, ma'am. This was on my rental property, not on my residential property. He was doing work on my rental property. He bought one can of paint, and he kept the paint in his vehicle along with the receipt. I never saw him after that.
Okay. When you got to the rental property that day, the next day, was Charles still there?
No, ma'am.
Had you seen Charles that morning?
I had not seen him.
On the 29th. You did.
No, they have not returned to my property since I gave him the check.
Didn't say. Showed up and did an hour's worth of work and left. So you did see someone. So let's not get fixated. You gave him the check on the 27th.
Yes.
Somebody showed up on the 29th.
And
who you refer to an older gentleman.
Yes.
Don't tell me what he did. He showed up.
Yes.
And you haven't seen either Mr. Young after purchasing the can of paint or this Charles since April 29th.
That's correct, Your Honor.
Now, would you show me a photograph of the steps as Charles left them?
Yes, ma'am. And I can tell you what this photograph shows.
Don't say anything just yet. Okay, so I'm looking at the railing. It looks like either the paint is off or was sanded off or is just off from where?
This is the only work that Charles did. He sanded this top railing of the stairs, and he put on the primer, the white area you see here, this is primer. About 1/10 of the stairs were primed. That's all the work that was done, period, at the end.
I got it. And you haven't seen them since?
Not at all.
Have you been in communication with Mr. Young?
Multiple messages following this.
Has he responded to you?
No, he blocked my text messages.
Judge Judy continues in a moment. Closed captioning sponsored by. Are you the victim of a scam? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay. Now, Mr. Young, certainly this job was not completed based on this photograph, and I assume you did not have a photograph.
Yeah, well,
show me a completed job.
Oh, no, not completed, no.
Well, of course not completed. Now, you want to tell me whether you were back to the property, and if you were not back to the property, why?
Went back and stayed until probably 5 o'clock. And I didn't just purchase one can of paint. We purchased more items than just one can. And
I don't know that. I want you to tell me whether or not you finished this job more than the photograph that I just saw.
Yeah, yes, of course.
That's very easy to...
Yeah, yes,
well,
of course.
show me a picture. Show me a picture.
I could, okay.
You knew that there was a dispute.
Yeah, only thing I have is this picture here, and and I have a picture.
Well, that's the picture that she showed me.
Yeah, that's the only picture I have that I took.
Then you owe her $800. Judgment for the plaintiff. Thank you. We're finished.
Thank you, Your Honor.
Case is concluded. Parties are excused.
And on the next Judge Judy.
I live with my ex-husband.
Must like him again.
He's my husband.
I never heard that before. Look at my age. I learned a new word.
Judge Judy.
I don't agree, of course.
That broke hustler owes so many people.
I'm not a hustler.
I'd like everyone to take a look at that scam artist's face.
You can't please everyone.
If he thought he was going to make me his sugar mama without my permission, I got news for that con man.
You owe him $3,950.
No, I don't.
The virus held up her security deposit.
I missed the walkthrough because I had COVID symptoms.
Your Honor, he didn't even let us know.
It's irrelevant to this case that you had COVID.
Now, a landlord holds nothing back.
You want me to go to a walkthrough and infect somebody with COVID?
Send your mother, send your father, send a friend. You're full of baloney.
This is Judge Judy. Michelle Spaulding is suing her former landlord, Kirk Wilterding, for the return of her security deposit.
Justice case number 113 on the calendar in the matter of Spaulding versus Wilterding. Parties have been sworn in.
Miss Spaulding, your case is a defendant owes you your security deposit back. You and your family rented a house from him.
That is correct.
He gave you a 60-day notice. You did, in fact, move out, and he retained $3,950 of your security.
That is correct.
So far correct? Okay, so Mr. Wilterding, I'm going to start with you, sir. The Spauldings rented your house. They gave you in security deposit $3,950,
Correct.
which you know you're supposed to keep segregated in a separate account. Do you know that?
I do know that, and it was
That's
segregated.
a yes? Good. And you can prove that to me if I needed it.
Sure.
Sure.
Yes.
In what bank did you keep it segregated?
I have it in a separate account that's one of my LLCs, not a personal account.
What LLC do you have there?
Just my account.
$3,950.
My account. And I actually sent them a copy because they asked for it.
Then I'm just asking you, why can't you tell me what bank you have their $3,950 in?
It's Wells Fargo.
Okay. Let's proceed a little further. According to you, you had a girlfriend, you were moving to California, you lived in your house for a couple of years, then you moved with your girlfriend, then COVID struck, and you decided you wanted to move home. They were already living in the house, you gave them a 60-day notice. That's what you wrote in your answer and swore to. Do you remember that? And you made a date to come with them as a result of your 60-day notice. You made a date to do a walkthrough with them before they left, which is what people do when they have a rental property so that the people are moving out, say, this is what the place looks like, and you have an opportunity to look at and say, this is my damage, and I'm going to deduct that from your security deposit. You don't have to put anything anywhere. You weren't feeling well on the day of the walkthrough. That's what you wrote, correct?
Correct.
And according to you, you lost your sense of smell because you had COVID.
What does that have to do with the walkthrough?
Well, it has to do with the walkthrough, sir, because you say by the time you entered the house and regained your sense of smell, that's what it has to do with it. You said,
I didn't say
that
any
in your
of that.
answer.
You're just making that up. I didn't say any of that.
Okay.
I missed.
Really?
If you would
Okay.
like me to explain,
Just a second.
I missed. If I can
No,
explain.
I'm just looking at it. I may, just a second. I may have been mistaken, so I'm going to read your answer. You said, due to COVID-19, I decided to move back into my house. I gave them a 60-day notice, and they complied. Michelle asked for her deposit back on the day they moved out. I told her she had to wait for damage checks, but you already had a date for a walkthrough, that you didn't go, missed their walkthrough. That's your sworn statement, sir. I have your signature on it.
It says nothing about smell.
Soon after that, I moved back into my house. I got COVID-19. Following my doctor's instructions, I quarantined until I felt better. It took a full month before I was symptom-free. That's what you wrote. When I finally got my sense of smell back, I knew I wasn't crazy. I can't make that up.
30 days later?
The smell of dog was obvious. The smell of dog was obvious, and I needed to change the carpet and pad. That's what you swore to in your answer, sir, right?
I missed the walkthrough because I had COVID symptoms. You can see I have a letter from my doctor, so I did not want to infect them. I didn't say that I didn't have smell.
I don't care.
And that's what...
No, just a second. You said...
30 days later.
You just said, I don't care, sir. You owe him $3,950.
No, I don't.
You missed the walkthrough.
There's more to the story. I missed the walkthrough because I was sick. I had COVID. So you want me to go to a walkthrough and infect somebody with COVID?
Send somebody in your place.
Your Honor, he didn't even let us know.
Send your girlfriend. So just a second.
I didn't have anybody available. It's a 2-hour drive. I have nobody available. I have nobody.
Send your mother.
No one.
Send
my
your
mother.
father.
My mother
Send
lives
a
in
friend.
Minnesota.
Hey, listen to me, sir. You're full of baloney because you
No,
lived
I'm
in...
not. Actually hear the story, and I have evidence. Why don't you let me talk?
listen to me. It's irrelevant to this case that you had COVID. It is totally irrelevant to this case.
Why do I wear a mask then? We're not supposed to infect people. We're supposed to quarantine. Really? So Judge Judy says nobody has to quarantine. No.
How many times have you had COVID?
No.
I've had it twice.
No. Shh. No. Listen to me, sir. Listen to me. Don't talk over me. I wouldn't suggest.
Well, you're not letting me talk. Why am I here?
Personally,
you're not letting me talk. Why am I here? Why am I here?
You're here to pay $3,950 judgment for the plaintiff. That's it. Out. We're done.
This case has been concluded. Parties are excused.
I'm honestly just happy that the truth came out. He clearly showed his true colors.
Because my whole house smells like dog. My brand new house, 2,800 square feet of carpet, smells like dog.
And that was my total interaction with him the entire time that we were his tenants.
They had it cleaned, they put perfume on the carpet, and it stinks.
Everything that comes out of his mouth is a lie.
So I have 2,800 square feet of dog carpet. It's $6,500 to fix. So their measly deposit doesn't even cover it.
I'm glad I'm done with this nightmare and I don't have to deal with him anymore.
All parties in the matter of Roberts versus Patton step to the podium.
Charles Roberts is suing Bryn Patton for the return.
Patton, I'm going to start with you, sir. Mr. Roberts had a non-running dirt bike, and you own a mechanic shop, and he asked you sometime last year if you could get the bike up and running.
Correct,
So far correct?
Correct.
So I want you to understand that Mr. Roberts, who I haven't spoken to yet, looks like a reasonably intelligent man. And you came out and you looked at the bike for the purposes of giving him an estimate as to how much it would cost to get this non-running dirt bike up and running. So far, am I correct?
Yes, Your Honor.
And you did, in fact, give him an estimate of what you thought, because you're the professional, of what you thought it would take to get the bike up and running. Correct?
After we went through it, Your Honor, and diagnosed everything and did a complete workup on it.
No, at the house, before you took possession of the bike, he asked you for an estimate.
Which we cannot provide.
Did you give him?
No.
Well, what did you look at the bike at his house for?
Actually, we just went to pick it up to get it going for him.
Okay, great. So you went and picked it up. On what date did you pick it up? Do you recall, Mr. Patton?
I don't recall the exact date, no, ma'am.
Do you recall the month?
April or May of
Ms. Pye.
It's unclear, and it's not documented. I believe it was March or April.
Say it was March in your papers.
That's my best recollection, Your Honor.
March of 2020. Okay, so you picked up the bike, Mr. Patton, according to you, and you took it back to your shop for a diagnosis and an estimate of what it would cost to fix it. And you didn't keep that estimate to yourself because you're in business. So you relayed that estimate to Mr. Roberts. What did you tell him it would cost to fix the bike after you diagnosed it? No, I don't want to hear the word basically or like or about. Now you took the bike back to your shop.
We were given the instructions to complete.
I'm giving you a question, sir. And what I suggest you do is a believable answer. If you don't, I assume you have family who are among the 9 or 10 million people who watch this program every day. I said to you at the beginning, Mr. Roberts is an intelligent person. If I took my bike or my car into a mechanic to be repaired, and they said I have to do a diagnostic, and they took the car to do a diagnostic, then they communicate with me as to what it will cost to fix it after they've done the diagnostic. So don't give me a lot of who shot John.
The moment.
Now, I'm not believing you.
Okay. Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity. Sir, don't look slick to me, sir. I can tell slick. Don't think of what I'm saying to you.
And later today.
I loaned her $1,000. The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
Tell me how that happened.
She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
Charles Roberts says mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
What I'm asking you, sir, is after the diagnostic, what estimate did you give them?
We were given an order to fix the bike and get it running so that it was in proper running condition. He was leaving town.
You know, I don't believe... Just a second.
Okay.
Now, I'm not believing you.
Okay.
Mr. Patton, I'm not believing you, sir.
Well, unfortunately, I'm telling you the honest truth.
Your answer belies credulity, sir.
It
belies credulity.
Well,
Somebody had a non-worker answer, whatever it costs to fix it, fix it. So now, since I don't believe you, I'm going to ask you a couple of other questions, because that's what this case is about. He wants his bike back, and you have a ridiculous counterclaim. Now, is the bike currently, don't look slick to me, sir, I can tell slick. Don't think of what I'm saying to you. Is the bike currently running?
Yes, ma'am.
And is it currently in your shop?
Yes, ma'am.
Okay. Now, are you getting an appearance fee for coming to this program today?
Yes, ma'am.
How much?
To be honest, I do not recall. This is the third time this has happened, and each time things have been very different. So with the COVID, things have...
Fine. So you don't know. Whatever it is, you know it's something,
That's right.
Okay, good. So nothing better happened to this bike, because they're going to hold whatever that appearance fee is until we make this exchange and we have a running dirt bike. Do you understand?
Absolutely.
Great. Now, originally you say he came out and looked and said maybe between $300 and $400. Okay, that's a good guesstimate. You know, that never is what it is. You never get charged exactly the top end of an estimate.
Right.
What you say to me is, in your complaint, is that in July, so we had March, April, May, June, now in July, both of the repairs had increased and would be $580. Do you recall texting him that figure, sir?
I texted many times. Oh, wait.
No.
I apologize.
Do you recall texting him that the bill, which originally you said would be maybe between $300 and $400, is now $580 in August? Do you recall saying that to him?
Yes.
Okay. We'll take a look at that text.
Here's the text. August 21st, he says $580 plus tax.
Plus tax on parts. So say the repairs was $600.
Fair enough.
Right? Say repairs was $600, but he said, I think I have a buyer. Forget any other deal. $600 with the repairs then. And according to Mr. Patton's answer, Mr. Patton, I want you to listen carefully. You said I had the bike fixed within a few weeks. So that $580 plus tax on parts was a completed figure. That's what the figure was. $600, which was twice the lowest estimate that I believe that you gave him, but a couple of $100 more than the highest estimate. And according to you, you said to him, I kept ill. He kept making excuses. When I told him it would cost $1,500, he complained. Why would it cost $1,500?
Judge Judy continues in a moment. And later today,
We were arguing, and I was being told that I'm not thankful for anything that he does.
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
Real cases, real people. Judge Judy. Charles Roberts says mechanic Bryn Patton owes for the return or value of a dirt bike. Bryn is countersuing for a repair bill and storage fees.
Now, why would it cost $1,500?
I don't recall why I don't know how that conversation even occurred. I don't recall it.
You don't recall telling him that the cost was $1,500 now?
Charging him $1,500? I do not recall that. No, ma'am.
Did the person who wanted to buy the bike, because I'm looking at that text message, Mr. Patton, did the person who wanted to buy the bike, was that your son?
He's my son, yeah.
Did he use it?
No.
Did he ever ride it?
Yes.
How many times? Once or more than once?
During the
once or more than?
More than once.
More than 10 times?
No. And it's just not my
Between
son.
5 and 10
we have technicians that ride it as we repair things. They have to be test-ridden.
No, I'm talking just about your son, sir, not about the technicians, just your son.
Oh, no, he only wrote it one time. The first time that he was going to write it. He wanted to see if he was going to buy it or not.
Okay, very good. All right, it's a relatively easy case, Mr. Roberts. You see, you didn't have to say anything. You have to give him $600. When you give him $600 and go and retrieve your bike, you can do that with a marshal. The bike will be in perfect running order because that's what Mr. Patton says. It's in perfect running order. And there are things that we will hold hostage in order to make sure that you get that bike in good running order for the cost of $600, which you think is fair, correct?
Thank you, Your Honor.
Very good. Very good. We're finished. That's it.
Thank you.
Thank you.
This case is concluded. Parties are excused.
Well, I think it's a fair decision. It's a little frustrating because he quoted me $300 to $400 to repair the bike.
I believe it was a fair decision. I believe we kind of came here and got the answer we wanted.
Then the bill came back as $580, and then when I went to pick it up, he presented me with an invoice for over $1,000.
There was a dispute between the payment.
Like, this is a hostage situation. I'm not going to play that game.
All parties in the matter of Swenson versus Miller. Step to the podium, please.
Doug Swenson is suing his ex-girlfriend, Kathy Miller, for an unpaid loan.
Mr. Swenson?
Yes, ma'am.
According to your complaint, sir, the defendant was your girlfriend for a couple of years.
Yes, ma'am.
From when to when?
It was March of 2017, I believe, up until September of 2020.
And it is your claim that just before the breakup, you loaned her $1,000.
Yes, ma'am.
You had a bad argument sometime in...
September 16th is when I was.
The answer says on October 18th, he showed up at my house unannounced about the money.
We could have the months.
But you broke up?
Yeah, it was in September.
In September, you broke up?
Yes, ma'am, on the 16th.
Okay. Did you go to her house to collect the money in October?
Ma'am. Yes, I did.
Okay. And you went to retrieve, according to you, the money she owed you?
Yes, ma'am. $500.
Hmm?
Yes, ma'am, the $500 that she owed me. That's why I went there.
Well, when did she give you any money towards the loan?
Okay.
I thought she gave you that money when you broke up.
Judge Judy continues in a moment. Closed captioning sponsored by... Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Now, you went to retrieve, according to you, the money she owed you.
Yes, ma'am. The $500 that she owed me. That's why I went there.
Well, when did she give you any money towards the loan?
Okay.
I thought she gave you that money
when
you broke up.
I loaned her $1,000. The night that the big fight went down, that she wound up leaving my house, she gave me $500 that night before she left.
She gave it to you. Look, listen to me. She gave it to you voluntarily?
Yes, ma'am. She said exactly to me,
Tell me how that happened.
Yeah. Okay, well, now here's what happened. She went out to her car, got the $500, came and handed it to me.
Is that the way it happened?
We were arguing, and I was being told that I'm not thankful for anything that he does because he came and helped me find the car. He knows about cars. So that night...
You were arguing. I want to know if you went out voluntarily and gave him $500 towards the $1,000 loan.
I did.
Did you do that?
Because he was putting it in my face.
Well, that's not what you said here in your answer, which is the only reason I'm hearing this case, because you said he blocked my car and give him the money. But that's not what you just told me.
That was the next day.
What do you mean that was the next day?
The next morning he came to my house.
I want to know when it was that you gave him the $500.
When he came to my house.
Not at his house.
No.
I don't believe either one of you. Actually, it doesn't make any difference. If you gave him the money, then you owe him the balance of $500, okay? And by giving him the $500, you acknowledge that you owed him $1,000, you gave him $500, you owe him $500. Oh, my God. Thank you very much.
Thank you.
This case is concluded. Parties are excused.
Thank you, Your Honor.
And on the next Judge Judy.
I think it was absolutely correct.
I guess it's fair.
I helped her out, and I felt she was very unappreciative.
Well, he gave me the money, and he said, don't worry about it.
We got in a huge fight. She wanted to leave my house in the middle of the night and stuff, and...
You know, don't take anything from anybody.
Yeah, I just, I wanted my money back.
Just do it on your own.
I
was in jail.
You were in jail for what?
For the assault.
There was 2 assaults.
It was a bad idea to bring back her ex.
They were telling me to get off the property.
Did you pay any rent?
No.
You were asked to leave.
Then he left her bloodied.
How did she cut her arm, Mr. Simple? How did she cut her arm?
Daniel pushed me.
This is Judge Judy. Cherie Zarate is suing her ex-boyfriend, Daniel Seifel, for rent and utilities, property damage, and an assault.
Judge's case number 96 on the calendar in the matter of Zarate versus Seifel. Parties have been sworn in.
Thank you. Miss Zarate, you and the defendant know each other, according to you, for well over a decade. And there was a time, according to you, that he was your boyfriend.
Yes, for sure.
When was he your boyfriend?
2007 to 2008.
Are you currently married?
No.
Who do you live with?
I live with myself, and I have a house tenant at the house that I'm at.
Is that your house?
Yes.
When did the defendant become incarcerated? In what year?
It was May of 2019 to August of 2019.
And after you were no longer involved with him romantically, did you maintain a friendship with him?
Yes.
Just friends or more than friends?
Just friends.
According to you, when the defendant owned a house
yes.
that another brother had lived in who recently passed away,
yes.
and you and your brother, or you, made an agreement with the defendant that he could live in the house and pay either $400 a month or rehab the house because the house needed a lot of work because the house was in bad condition.
Right.
That's what she says. Just a second. And your lawsuit asks for $5,000 because you say he did not do anything in the house.
Right.
He did not do work in the house.
Right.
He did not pay rent.
Right.
And he assaulted you.
Yes.
That's what your case is about.
Yes.
Okay. Have I pretty well rounded out what your case is about?
Yes.
Yes. Now, let's deal with the assault first, sir.
Okay.
You were living in the house for a while, over a year.
Yes. Yes.
You were living in the house for over a year.
Yes.
And you paid no rent.
I was not, that wasn't the agreement.
Just a second. Just answer my questions. Did you pay any rent?
No, I wasn't asked to pay any rent.
Just a minute. There has to be a reason, sir, that you weren't asked to pay any rent. I'm asking you these questions because I have an objective. So you lived in the house for a year. Ultimately, you were asked to leave.
Yes.
And there was an altercation involving the plaintiffs. And the plaintiff, in addition to having the police there, filed for a protective order against you.
Yes.
And that case went before a judge.
Correct.
And you were present.
Yes. Went to court.
Did you have a trial?
Yes.
Did you testify?
Well,
you said yes or no. Did you testify?
No.
Did you consent to her having an order of protection?
I'm not aware of that. No.
Do you know whether she got an order of protection?
I was told, but I was never served. I was in jail. I was taken
You
to
were
jail,
in jail
the
for
next
what?
For the assault.
Right. Do you have a copy of the protective order?
Yes.
May I see it, please? Okay, so the proceeding was not for an assault, it was for harassment. Is that right?
It was for both.
I don't see anything about an assault there.
Okay, there was 2 assaults. The first one was on August 29th. The second one was on November 11th. And when they arrested him the second time, the police officer told me to go file for another restraining order, limiting him more.
No, just a second. The assault
August 29th.
was on August 29th.
Right.
That's it. Do you have photographs of your injuries as a result of that?
Yes.
I'd like to see them. How did she cut her arm, Mr. Simple?
They were coming at me, her and the Beverly girl, and I pushed them in an open hand, and she fell against a stereo.
Okay. How did you cut your hand?
Daniel pushed me. After he pushed Beverly.
Okay, and what were you doing with him on that day?
Beverly and I confronted him about not paying anything since April and having his stuff all over my property. And I got a letter from code enforcement saying that they were going to fine me $500 a day if he didn't clean up the stuff from my yard. And
because he brought a whole bunch of stuff from your yard.
Yes.
Would you show me a photograph of your yard?
Oh, yes.
May I see it, please?
And there's another.
Who's mobile?
I'm sorry. That's the motorhome I stay in because the house needed to.
So you stay in the mobile home on the property?
Yes.
Well, whose bicycle is that?
All that stuff is Daniel's. Everything in the yard.
What about the lumber? He got out of, is that all your stuff?
That's material that I brought there to work on the house. That is my bicycle.
Well,
yes.
the lumber. I mean, he didn't get out of jail and they didn't give him lumber. They give you $1 to go on a bus. They don't give you stacks of lumber. So evidently he bought that, but he didn't use it inside the house.
Right.
You live in the trailer behind with a friend.
No,
is that right?
Myself. I lived in by myself.
You lived there by yourself?
Yes, in the motorhome, yes.
Yeah. When Daniel was in the house during that year that he was there and you were living in the motorhome, he was living in the house?
Yes.
Did you ever have dinner together?
No.
No?
Yes, we did.
Did you ever have dinner together?
Yes.
Did you ever have more than dinner?
No. Conversation? No.
Just conversation?
Conversation. I bought materials for the house to fix it up.
Yeah, well, it looks awful, and you wouldn't be living in a motorhome if you could live in the house. Okay. You pushed her, sir, and another judge, another person who has the same quantum of proof that I would have to if I heard this case, found that she was entitled to a protective order. And you're not allowed to put your hands on somebody. You're not allowed to do that.
I felt that I was
She has to be compensated then. Yeah. Now, do you drink?
On occasion.
Sometimes?
On occasion, sometimes, yes.
On occasion?
Yes.
More often than not?
No.
Okay. Now, how long did you...
I knew nothing about paying any rent.
When she told you to move out because you weren't doing your end of the bargain, how long did you stay in the house after she told you to move out?
I left. I was arrested the next day. When they told me to move out, that's when they came at me and I pushed them away.
That's August.
They
and then
were
you moved
telling
out.
me to get off the property.
Just a second. Just a second. They told you in August. Did you move out in August?
Yeah.
Did you move out in August? Did you ever come back?
Occasionally. I would come back and try to get some of my stuff. I had a stay-away order, so I had to take a police officer over there to get my stuff. All my stuff that I bought for the house, the materials, supplies to fix the water leak in the house, is still there.
Well, a lot of that stuff is just junk.
No, this is brand new stuff. Still
That's in the
box.
backyard. No, a lot of the stuff that she just showed me was junk. Well, the bicycles look like junk.
Okay,
I don't know whose they belong to.
That was something that was brought in there before I started getting the water leak fixed in the house.
Okay.
Damages, she said, was a drywall in the house, but it had a water leak and I had to fix. I bought the material to repair that.
All right. Ms. Cerati, let me explain something to you. I don't believe that he owes you any rent. Somebody that you knew, you made a ridiculous arrangement with him, but he does owe you for this assault. Other than this cut on your arm, because I don't think he has a right to put his hands on you and receive any medical treatment for your injury.
No.
Okay. Who is living in the house now?
No one right now.
And you're not living in the trailer either?
No, I'm in the motorhome. I'm still in the motorhome.
You're in the motorhome?
Yes, because the house still needs fixed.
And where is your brother? Of course. Where is your brother?
My brother lives in L.A. right now, but he's coming out in a few months to live at the house.
Well, somebody better fix it up.
Yes.
Judge Judy continues in a moment. And later today.
You opened your car door. You weren't looking where you were going. Didn't even look. Didn't even look. Opened the car door. Didn't even look.
Cherie Zarate says ex-boyfriend Daniel Seipel owes for rent and utilities, property damage, and for injuries she suffered during an assault.
All right, I'm awarding you $1,500 for the injury that you sustained. He doesn't have the right to put his hands on you. Sir, where are you living now?
Where am I living? At my friend's house. My friend's house.
Do you pay rent?
No.
Good for you. Okay, we're done. Thank you very much.
All right, thank you, Your Honor.
This case is concluded. Parties are excused.
They were coming at me, telling me to get off the property. That wasn't the agreement. I was never supposed to pay any rent.
He was just bringing junk and dumping it in my yard.
Well, she didn't want to hear anything that I'd bought materials to fix the problem in the house.
I've been slowly fixing it myself.
I just got the materials to work and they said, get out.
I think he's a hoarder. He just collects things.
It was aggressive, yes.
Just harassment, and I didn't want to have to be calling the police every other day.
Not to do it again.
I'm just glad that he's finally out of my life.
And now, the next case.
All parties in the matter of Koska versus Zurati. Step forward.
23-year-old Brittany Koska is suing fellow motorist 22-year-old Sabrina Zurati for damage to her car caused by an accident in a university parking lot.
Oh, my goodness. That is a familiar scenario. Okay. P, that would be you. It's pulling into a spot.
Correct.
When were you pulling into the parking spot?
It was on February 14th at 7:45 a.m.
Where were you going?
Cal Poly Pomona.
To school? And you?
School. Same school.
Okay. So you're pulling into the spot, and?
As I was pulling in, I was halfway into the parking spot when she swung her door open and hit my front bumper. As I got out of the car, she got out of the car and indicated she was sorry she didn't see me. Therefore, so then I asked for her insurance information. She said she didn't find herself at fault and would like to discuss it with her father. She walked away from the scene. As I called the police, I texted her saying I called the cops.
Okay, then she came out. Anyway, that's what it is. And she says, Miss Sarita, you say, go ahead.
So, what her statement is actually incorrect, Your Honor.
No,
my door was
just tell
already
me. I'm
open.
listening to your story.
Okay, so my door was actually already ajar. It was partially open.
Show me how ajar with your hands.
So this is my vehicle. I was about this open in my parking spot still. And she pulled, there's an empty spot next to me. She pulls in, obviously in a hurry, and she hits my car. She impacted it. So we get out of the car, and I've never been in such a situation. So I ask, okay, what should we do? She's like, just give me your information.
Okay. I don't care about the information back and forth. So you say that your door was partially ajar. I'd like to see the damage to your car.
Okay.
Was there any damage to your car?
No. The door's steel. The bumper's plastic, so.
Well, if she were going fast, then what would have happened is, as you indicate,
Obviously
your
going too
door,
fast.
your door would have come off if she hit your car door.
It's kind of hard to see since the car is black, but it was fine.
Okay, so I have parking space, and you're being vigilant about what's around you.
Correct.
And you see the defendant's car.
Correct.
Did you see her in the car?
I did see her in the driver's side.
If you saw her in the car, you knew she was getting either in or out, right?
Right.
So you had a 50-50 shot whether she was getting in her car or out of the car.
No, that's incorrect, because
Sure
since
it is.
we're at school.
She couldn't have been going up or down. She had to be going in or out.
Correct.
Or sideways.
Judge Judy continues in a moment.
Were you covered at the time for liability?
I didn't realize, but it was lapsed.
So the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you'd had lapsed insurance, it means you didn't have insurance.
Correct.
Don't say it was lapsed again.
Real cases, real people. Judge Judy. Brittany Koska says fellow motorist Sabrina Zurati opened her car door just as she was pulling into a parking space next to her. She is suing for the cost to fix her vehicle.
Now, what you're supposed to do is, when I'm driving and I see a passenger, you know, I'm driving, I'm saying to myself, are they going to get out of that car? So I'm going to slow down and be really vigilant until I pass them to see what they're doing. That's just common sense. Now, she was almost in that spot.
She actually wasn't, Your Honor.
Sure she was. She had to have been. You didn't say that that's not how the accident happened. You're not saying that that's not what...
My door was already open, Your Honor, and she pulled in.
Listen to me.
And she hit my parked car.
No. No, you keep saying that over and over again. What I'm telling you is that when you got out of the car, you weren't being vigilant enough.
I don't have eyes behind my head.
Oh, just a second. Well, you're supposed to. You're supposed to
She
be
was
able to
obviously
look
in a hurry,
out.
Your Honor. She was obviously in a hurry because she wouldn't have hit my car. She didn't even want to exchange information because she was in such a hurry.
I think that you both weren't being terribly careful. Do you have insurance?
Yes, I do.
Were you covered at the time for liability?
I didn't realize, but Your Honor, it was lapsed.
So the answer is you didn't have insurance.
Correct. However, it wasn't my fault, so...
Just the answer is you didn't have insurance.
Correct. It was lapsed.
You think you're going to get in the last word? If you had lapsed, and you'd say it was lapsed again. You didn't have it. I didn't say you never had it. You didn't have insurance.
Correct.
Do you have insurance?
Yes.
You have liability insurance.
Yes. I don't even think she's on the insurance because her name's not on the insurance card.
Name doesn't have to be on the insurance card.
Just want to make sure.
The car has to have insurance.
Correct.
Your car had no insurance. However, I do think that you were partially responsible for this accident. I think that you were probably not vigilant enough and not careful enough. So was she, because she got out of the car, whether she kicked the car. What kind of car do you have, by the way?
I have a Honda.
When you say my door was partially open, when you usually partially open a door, it's because you're doing something. If you're getting out of a car door,
I was reaching over to get my belongings.
Oh, just a second. Hold on a second. So you were reaching over.
My
to
door
the
was already
passenger
open.
side. You were reaching over. No, I don't believe. If she hit your car that way, it would have taken your door off.
It wasn't all the way open. She hit the edge of it.
You're sealing it for yourself. You opened the door partially to let some air in the car. You turned off the car.
It was already off. Then I opened my door.
Oh, it's getting... You don't realize where you're going.
Judge Judy continues in a moment.
I want you to go step by step with me. You turned your car off.
I reached over to get my...
My door was already open. It didn't open
I turned
by
my
itself.
car off.
You
I
turned
opened my door.
Slowly.
Closed captioning sponsored by... Are you the victim of a scam? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Okay, so you turned your car off. I want you to go step by step with me. You turned your car off.
Turned my car off. I took my keys out of the ignition. I reached over to get my belongings. My door was already open.
No. I don't want you to say my door was already open. It didn't open by itself.
Car off. I opened my door.
You turned the car off.
Correct.
Step by step. You turned the car off.
Right. I set my keys down.
You set your keys down where?
On top of my purse, in my purse.
On top of your purse, which was where? On top of your purse, which was where?
On the passenger side.
Where your books were in your pocketbook, right?
Correct.
And then, slowly, you took the key out of the ignition, you put it on top of your purse, you reached over to the side to get your stuff. And
I opened my door. I set my keys down in my purse, on top of my purse. I opened my door, and then I leaned down to get my books, and that's when she impacted my car.
No, didn't happen that way at all.
Okay.
No way. Tell me the truth. You have an estimate to fix your car?
I do.
That's not what happened.
Either way, she hit a parked car.
No. You opened your car door. You weren't looking where you were going. Got your things, took the keys out of the ignition. I believe that. Bent down to pick up your stuff. Believe that. Didn't even look. Didn't even look. Opened the car door. Didn't even look. That's what you did. Judgment for the plaintiff in the amount of $25.65. Thank you. That's all.
Why is that excused? You may step out.
Judge Judy continues in a moment. And on the next Judge Judy... The landlord who never left.
You slept in the laundry room next door to his apartment. That's ridiculous. You're a scammer and a fraudster.
Next, Judge Judy.
She had her sunglasses on, 7 a.m. in the morning.
Usually when it's sunny, I wear my sunglasses, so I don't know if that really causes somebody to be distracted or not. I could see if I didn't have my sunglasses on, maybe that would distract me.
She obviously was going really fast. She hit my car. Obviously, her car was damaged.
No, I was not. I'm pretty sure if I was, her door would be off.
She was going so fast, she was in a hurry. Of course, she wasn't paying attention.
Her door open, I hit it, and she said she was